Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, ombuds, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and the fellow of the American Bar Association section of dispute resolution. I'm delighted to welcome Aaron Gothelf to the EVER Show. He is the Vice President of the American Arbitration Association and AAA Commercial Division for the Pacific region, overseeing California, Oregon, Washington, and Alaska. He serves as the National Chair of the AAA's Entertainment Dispute Resolution Advisory Council and the Western U.S. Chair of AAA's Healthcare Dispute Resolution Advisory Council. Before joining the AAA, Aaron was the Northern California Regional Director for Judicate West, a leading provider of mediation and arbitration services in California. He currently serves as the Educational Programming Officer of the American Bar Association Dispute Resolution Section and Chair of the ABA Forum on the Entertainment and Sports Industries, Motion Pictures, Television, Cable, and Radio Division. He wears so many hats, so I've left the links to his profiles below. And welcome to the show, Aaron. Let me stop sharing now.
Thank you, Chinwe. You make me sound a lot more impressive than I really am, or important than I really am, but I appreciate that.
Thank you once again. So without further ado, the first question is, what is American Arbitration Association?
Okay, so I know alternative dispute resolution, ADR, is done differently in countries across the world. Yeah. In the United States, we primarily divide neutrals, and when I use the term neutral, I mean anybody who's a mediator, an arbitrator, early neutral evaluator, etc., into kind of two groups, right? So you have folks that are independent neutrals. They kind of work on their own, or they're part of a law practice and do ADR on the side. And then you have individuals that are part of a provider. And the American Arbitration Association is a provider of ADR services. All of our panelists are independent contractors. They're not employees of AAA. And as cases come in, we find ways to get them on mediations and arbitrations. So a little bit about AAA, my cheat sheet here and all my notes, because I want to make sure I get the dates right.
Yeah.
So the American Arbitration was founded in 1926, following the passage of the Federal Arbitration Act, also referred to as the FAA. So, we're at 97 years right now. We're hopefully going to make it to 100. So we've been around a long time.
Yeah.
We were the first national ADR provider. In the United States, there are lots of, I would call, smaller regional providers that only operate in one state or one city, but we have panelists in all 50 states, as well as many U.S. territories. We have been administering international disputes since 1951, but in 1996, the AAA established the ICDR, which is our international wing of the American Arbitration Association. And you've probably seen maybe in England or in other places in Europe, ICDR cases taking place. And AAA is currently the world's largest global provider of dispute resolution services. So we're the largest in the world.
Okay, thank you so much. So you've touched on how why it was created. So can you tell me if it has enhanced access to justice in the US so far?
Sure, absolutely. So you have to go back and kind of understand why the American Arbitration Association was created. So in 1925, there was somewhat of a crisis in the court system in the United States. There weren't enough courts, there weren't enough judges, there weren't enough juries, and litigation was backed up, it was stalled. So Congress got together and said, hey, we need a kind of an alternative means of moving cases through. We'd like to introduce the concept of private judging or arbitration. So with the passage of the Federal Arbitration Act, basically a year later, the AAA was created to handle cases. Now, people talk about access to justice, and one of the biggest issues with access to justice is obviously time, courts being backed up and things like that. And they say justice delayed is justice denied. You've probably heard that a couple times. And the whole promise of arbitration is to be a faster or more cost-efficient way of resolving disputes. Also, one thing that's unique about AAA compared to some of the other providers is we handle cases of all dispute levels. So we're talking about cases, where the claimant's seeking a couple $100, a small consumer case, all the way up to multi-billion-dollar business-to-business type cases. Mm-hmm. Now, those smaller consumer cases, in the United States, a lot of the other providers really aren't interested in that kind of work because the dollar value is so low, and the arbitrator or the arbitral institution really doesn't make a lot of revenue off those types of things. But at AAA, we handle those cases. And if it wasn't for us handling consumer cases, essentially all these cases would have to go through what we call small claims court. And small claims court in the United States tends to be, fairly backed up. The judges that, preside over these cases tend to be pro tems or volunteer judges. And there's just it's not a very efficient way of handling disputes. So that's really one of the ways we've enhanced access to justice. We also, have lots of pro se claimants and respondents. That's something I think that's kind of unique. Other arbitral institutions, I think, tend to have more parties that are represented by counsel on both sides, but we certainly don't require the parties to be represented by counsel. So that's another area where I think we're enhancing access to justice.
Thank you so very much. So, compared to the traditional litigation, how is there any measurable difference or impact on the cost and time frame for settling disputes or conflicts via arbitration?
Yes, very much so. And before I touch on that point, I forgot one last point that I wanted to mention. We're going to talk about access to justice. Very important here at AAA. We're a nonprofit, and that makes us very unique among the other ADR providers that are mostly for-profit and have shareholders and owners and whatnot. So we do a lot of pro bono work, if you will. One of our programs or things that we specialize in is during natural disasters like Superstorm Sandy or Hurricane Katrina. We were running essentially a mediation program that was free to homeowners whose homes were damaged that had pending claims against their insurance companies to try to head off some of the litigation that was heading to court. In the United States, if your insurance company denies your claim and you feel you were wrongfully denied, it's called an insurance bad faith case. Hundreds of thousands of these cases are filed every year in the United States. And we provided a service to sit down between the homeowners and the adjusters or the insurance companies and work out resolutions. So that's another area of our access to justice. Okay. So I'm going to give you some statistics. These are available on our website, and these are not necessarily the most recent ones, but on average, U.S. district court cases took more than 12 months longer to get to trial than cases adjudicated by arbitration. So you're looking at 24.2 months versus 11.6 months. So basically twice as long in federal district court. Okay. And then U.S. district court and circuit court cases required at least 21 months longer than arbitration to resolve when the case went through appeal. So you're looking at 33.6 months versus 11.6 months. And in the United States, we have a very elaborate appellate system, if you will. And cases can take many years to work their way through the appellate system.
Oh, thank you so very much. So, because in recent years, it's been most scholars have stated that arbitration is fast becoming expensive, like the traditional litigation. So I needed it to enlighten us about that. So thank you so very much. So how does one initiate arbitration via the AAA?
Sure. So I'm just going to give you an example of a typical large complex case track case.
Yeah.
These tend to be cases with claim values in excess of $1 million. So arbitration is a creature of contract, as we say. So the vast majority of arbitrations that come to the AAA are because the American Arbitration Association is written in as the provider in the arbitration provision in the contract, right? So you're a company, you want to file an arbitration, let's say, against another company for breach of contract over a service agreement gone awry or something like that. You would basically, all of our forms are on the website. You'd fill out a demand for arbitration. You would submit the appropriate case filing fee, which is based on the size of the claim, along with your actual complaint. A complaint would be the same thing as when you're filing a lawsuit or something like that in regular court. You don't necessarily have to submit a formal complaint with your demand for arbitration form, but it's always preferred. And at some point, you're going to have to probably submit a formal complaint so the arbitrator can actually understand in detail what it is that your claim is about. Once everything's been submitted, the case is assigned to a case manager. One difference that we point out here at AAA between some of the other providers is at the AAA, case managers are assigned to cases as opposed to being assigned to specific neutrals, right?
Okay.
And the case manager at that point will review the case file, see if there's anything that might be missing, make sure all the proper fees are paid. And then at that point, set up an administrative call. And on that administrative call, that's when everything from arbitrator selection and what the parties are, timeline and all that kind of stuff is discussed.
Oh, thank you so very much. So, with the processes, would you say it's sort of the same thing with litigation? It's so formalized and it might take a bit of time as well.
Yeah, it's similar litigation in the sense of kind of the process of when you file a claim versus filing a lawsuit.
Yeah.
There are similarities in the process, but the timeline for filing a lawsuit is much longer in the United States, especially if you're filing a demand for a jury trial.
Mm-hmm.
In some states, your trial date might be 3, 4, even 5 years from the date that you filed that demand for a jury trial. And I guess the good thing is in the United States, 97-98% of all cases filed that demand a jury trial are resolved prior to trial through mediation, possibly arbitration, or just the informal passing back and forth of offers and counteroffers and things like that. So most cases don't go to trial, but the court system, at least in some states, is doing a pretty good job trying to head off cases going to trial by requiring what we call MSCs. They're called mandatory settlement conferences. It's almost like a form of court-mandated mediation to see if there's any way we can stop this case from proceeding forward, because that frees up the calendar to handle jury trials where you really do need to have a full-on jury trial.
Oh, okay. Thank you so very much for that. So how does AAA handle cyber security?
I'm sorry, could you say that again?
How does AAA handle cyber security?
Cybersecurity. Yeah, well, just real quick, could I just go over what the arbitration process looks like kind of from start to conclusion?
Oh yeah.
So we just talked about filing and initiation.
Yes.
So that's the first step.
Yeah.
All right. And then the next step would be after the administrative call has been had with the case manager and the parties, the arbitrator selection process. So the first place we're going to look to for the arbitrator selection process is going to be the arbitration clause itself. And it's going to say things, for example, what type of rules are going to be followed? Is it the commercial rules? Is it the employment rules, construction rules, whatnot? Typically, where will the seat of the arbitration be? Will the evidentiary hearing be held in what city and what state? The number of arbitrators, sometimes it's silent on that. Sometimes it's going to be a single arbitrator or 3 arbitrators. In the process for appointing those arbitrators, sometimes it's party appointed, where each side picks one of the wings and the 2 wings pick the chair, or some other elaborate process. Most cases, though, typically go through kind of a rank and strike process, where the case manager basically sends out a list. The parties kind of rank and strike who they like, and hopefully we can get to a result that way. Once the arbitrators are in process, you're going to have the preliminary hearing. Preliminary hearing is going to be the first kind of point of contact, if you will, where the arbitrator themselves sets out the scheduling order, basically the timeline for the entire case, talks about discovery timeframe, when the evidentiary hearing dates are going to be, what possibly post-hearing briefing schedule, that kind of stuff. The next step would be discovery. Now, I know in England and in Europe and in the rest of the world in general, discovery is a relatively quick process. In the United States, discovery can take a long time. In fact, it's going to take, that's the majority of the time in an arbitration is going to be spent doing discovery. At AAA, we really promote settling disputes before they go to an evidentiary hearing. So we have what's called the mediation step, where we require cases over a certain dollar figure to make a good faith attempt at mediation. Oftentimes the parties will stipulate out of the requirement, but sometimes they actually take us up on the offer and do the mediation, and the court case is resolved that way. The evidentiary hearing, which would be like the trial, if you were to like go in regular court. Post-hearing briefing, where the parties get to, discuss anything they might have not addressed during the evidentiary hearing. And then the interim award, which is when the arbitrators release essentially their what they, who's the winner, who's the loser, whatnot, how much money is going to be divided, and all that. And then those typically arbitrators on big cases will do a period where there's a request for attorney's fees and costs, and that is settled, and then it goes to a final award where those issues are addressed. So that's kind of the whole process in a nutshell.
Okay, thank you so very much. So back to the question, how does AAA handle cybersecurity?
Yeah, so we have our whole online portal system. It's called the Panelist eCenter, which is for our panelists. This is a secure document place where panelists do everything from fill out disclosures to keep motions and upload invoices and all sorts of stuff. So basically, it's a document management system, if you will, and that is secure. It's our product. And for parties, we have the AAA web file, which interfaces with Panelist eCenter. And the web file is, like I said, where they upload motions and briefs, and award documents are uploaded, that kind of stuff. We also have pretty strict cybersecurity policies for AAA employees. And I was just joking the other day, they test us on cybersecurity all the time by essentially sending out like fake phishing emails and things like that. Like the most recent one we got was one that we had won like a free Starbucks gift card. Just, click on this link to get access to your card. And it looked really legit, like I didn't fall for it, but it said it came from like starbucks.com and all that kind of stuff. So we're constantly drilling our folks on cybersecurity, as well as working with our panelists, making sure that their security protocols and their computers are set up properly, that they're not clicking on phishing emails and whatnot. And it's also really important, cybersecurity arbitration is supposed to be kind of is supposed to be a confidential process, right? Unless somehow it gets dragged into the court system. And we handle a lot of high value, sometimes our cases might involve celebrities or professional athletes, kind of high profile individuals. We want to make sure we keep all that confidential.
Thank you so very much. So how does one become a panelist with the AAA?
Yeah, so there's the 2 main ways are we get obviously unsolicited resumes and unsolicited letters of intent, people that are just reaching out to us via email saying, hey, I'm interested in becoming a panelist. What do you think? And then there's the other way where someone such as myself, a regional vice president, will actually go out and try to recruit specific people. And the types of folks that I look for are obviously retired state and federal judges, attorneys, preferably partners at AmLaw 100 firms. AmLaw is simply the largest 100 law firms in the United States. And then people with backgrounds that match practice areas that I might be looking to recruit for. And that can change on a monthly basis based on my needs. Sometimes somebody might make a really good panelist, but I simply don't have the caseload to support kind of their practice background for cases. And then just, we have obviously standards and requirements here as far as what we look for in folks. And this is on the website as well, but I'm just going to go over it. So a minimum of 15 years senior level legal, business, or professional experience. Now, I want to point out there, I didn't say just legal experience. While primarily our arbitrators are either retired attorneys or retired judges, if you are, for example, doing construction defect arbitrations, and your background is you're a licensed professional civil engineer, that's a great background for doing that kind of work. So you don't necessarily need to be a judge or a lawyer to do those types of cases, because we know an engineer understands something about construction. Same thing if you were an architect, right? If you're handling accounting malpractice cases and your background is you're a CPA, that's the right background for that. So occasionally we do go outside the traditional background, which is having a legal education, and we call those folks subject matter experts. Education, degrees, professional license in your appropriate field of expertise. So, right, you're an engineer, you would have a degree in engineering and an engineering license. You're an accountant, you'd have a degree in accounting or finance and a CPA license. You're a lawyer, you went to law school, you have a law license, right? It's pretty straightforward. Obviously, knowledge of cybersecurity and the risks associated with certain types of technology. Once again, we want to keep people's information safe here at AAA. Training in arbitration and other forms of dispute resolution. So while folks that we invite to come on the panel, we have kind of an internal training program for, a lot of people that come to us have already completed, say, their mediation training certificate, or they've taken some classes in arbitration, or they've even been arbitrating, on their own cases. They just haven't been affiliated with a provider. Honors, awards, citations indicating leadership in your field. Obviously, the easiest thing is I'm a lawyer, right, by training. So I'm associated with lots of local bar associations. I'm an officer, right, on the ABA's, in the ABA's dispute resolution section. I sit on a number of different ABA sections and boards. And occasionally I receive an award, right, for my work. So that's all important stuff. Again, membership in professional associations, accomplishments and published articles. It always looks good when you're doing scholarly work in addition to your regular legal work or whatever it is that you do, because I always say this, the first thing someone's going to do if they've never heard of you is they're going to Google you, right? And when they Google you, really only three things can come up: good stuff, bad stuff, or nothing at all, right? Yeah. And a lot of times, nothing at all is almost as bad as having bad stuff come up. So a lot of times your scholarly work might come up in a Google search or something like that. It allows people to get an idea of you. The same thing too with, speaking at conferences and bar associations and teaching CLEs, that kind of stuff.
Thank you so very much. So how has the AAA worked to increase diversity amongst its panelists?
Sure. Diversity is very important here at the AAA. It's no secret that for a long time, the vast majority of arbitrators in the United States were white males. If you looked at the makeup of a law school class 60 or 70 years ago, it was almost entirely white males. So we feel that the diversity of our panelists on our roster should match the diversity of our clients and the parties that are involved in our cases. So the first thing starts with education. We host a number of events for diversity here at AAA, including the Diverse Student ADR Summit. This is a wonderful program where we fly law students from all over the country, come from various diverse backgrounds to our headquarters in New York for a couple of days of training and kind of an introduction to ADR, if you will. And then we also have the Higginbotham Fellowship, which is a fellowship designed for diverse practitioners. These tend to typically be attorneys, maybe 10 to 15 years out of law school that have been practicing for kind of that period of time that are thinking about getting into ADR. And the fellowship is a wonderful program because once again, you get to go to New York and kind of meet the folks that run AAA and kind of see how ADR is handled from a provider perspective. But more importantly, you're paired up with a mentor, somebody you can shadow, somebody you can talk to in the geographic area in the United States, kind of where you live, right? And I think mentoring and finding a mentor and shadowing, when I was at the last provider I worked for, I spent a lot of time observing mediators, right, that we were thinking of bringing on our panel. And I wasn't, judging them or saying like, well, I don't like this person's style versus that style. It was more for me just to become familiar with how different practitioners handle cases. And the value of shadowing is where you learn a lot of, the tips and tricks and internal ways that mediation and arbitration works. So having that mentor is really important. It's also important because if you go into ADR, even if you're on a provider's panel, it's like kind of starting your own business, right? And having somebody who's been successful in the space that you can follow around and learn from is really important. Recruiting. So obviously, I look for diverse neutrals to recruit as candidates to the panel. Various bar association events I go to, some of the minority affinity bars that I attend or speak at, things like that. And just for also some of the best panelists that we have here at AAA were suggested to me by current panelists saying, hey, I've got this friend who's looking to get into ADR. They're a partner at X and X law firm, whatever it might be. I think they really would make a good arbitrator. And a lot of times I find, diversity that way. Our rank and strike lists. I mentioned that when sometimes during the arbitrator selection process, if the parties can't agree mutually to who they would like to, select, we go to the rank and strike process, and depending on the division, we have a certain kind of threshold for a percentage of diverse neutrals that we're going to put on each list. And that's very effective in getting diverse neutrals appointed cases. And then supporting, diverse organizations. And one of the ones that I noted down was NAMWOLF, which is the National Association of Minority and Women-Owned Law Firms. That's kind of like the big trade group for minority and women-owned law firms in the United States. They have an annual conference every year. AAA sponsors it, and we usually send folks to that event. So we take diversity very seriously here at AAA, and we take a lot of pride in diversifying the profession, not just racially, but also, gender, LGBTQ plus folks, people with disabilities. We really look at the whole sphere of diversity here at AAA.
Oh, thank you so very much for that. So, how has the awareness of ADR grown in the general public?
I'm sorry, can you repeat that? The volume on my...
So how has the awareness of ADR grown with the general public
Sure.
in the US?
Yeah, so, arbitration in the United States, I still think is relatively unknown exactly what that means to the general public. Obviously, attorneys and judges and people in the legal field know about this. In the States, you typically hear the term arbitration through the media when there's an interesting story involving arbitration. Yeah. And in the United States, we're really into sports, right? So all of the professional leagues, basketball, football, baseball, et cetera, have, for example, arbitration panels related to salary arbitration. So football player or basketball player is kicked off of the team. The player feels that they're still owed money under their contract or something like that, that their salary is something that would go to arbitration. Again, the vast majority of civil suits in this country are settled by some means other than actually going to trial, whether that's a bench trial or a jury trial. But arbitration, I still think, is not fully understood by the general public outside of, unless it's a professional athlete or a celebrity or somebody in the news that's somehow involved in arbitration.
So my question is, what are you going to do about it? What's the AAA doing about it? Because when I conducted a research in Washington and Las Vegas, of course the masses on the streets, they don't know about ADR. They're asking me, where can we get a provider? Where can we get a practitioner? So what is the solution to make ADR more popular, for the people, for the masses?
I think ADR classes to some extent should be part of just general undergraduate college business classes, right? Someone's a business major or a finance major or marketing or something like that. If they're going to go into any kind of business, I kind of, a lot of business majors in college have to take a business law class as undergraduates as part of their degree requirement.
Yeah, right.
I've taken that class, and I can tell you there was no discussion of mediation or arbitration in the business law class. I think that could be added in there. We're exploring possibly a program here at AAA to reach out to local, small business associations and chambers of commerce to kind of talk about the values of ADR and possibly, writing in arbitration provisions into the contracts and things that they might have. And that, I think, is something that would expand people's knowledge of ADR. But essentially, you have to kind of go beyond the legal community that you're always so used to speaking to kind of get the word out. And I can tell you, there are various states that are more pro mediation arbitration, and some states that are somewhat con, especially in the consumer arbitration context or the employment arbitration context, right? So the industry itself has to do a better job explaining to folks what mediation is, what arbitration is, and why it's a good way to resolve disputes.
Well, thank you so very much. I truly appreciate your insight. And I would want to also state that they could start a show on ADR, mediation, arbitration as well, and also do some adverts on the television, because most people, non-academians or non-specialists, they watch television a lot and listen to podcasts as well, on YouTube as well. So if
I don't think anybody wants to see me on television, but if you can get me on a sitcom or a comedy or something like that about ADR, like I'd be happy to do it. I can play an attorney, right?
Oh yeah.
All right, I know you're short on time, but I just can I mention the AAA ICDR Foundation and kind of what that is?
Oh yes, please go ahead. Yeah.
Okay, so I mentioned that we're a nonprofit, but we have somewhat of a nonprofit within a nonprofit, and that's the AAA ICDR Foundation. It's a 501c3, and essentially, and I'm going to read our mission statement here. The foundation is a 501c3 nonprofit organization that funds critical domestic and international projects. This effort fills acute needs in the ADR community by expanding the use of ADR, improving the process, increasing access to ADR for those who cannot afford it, and sharing knowledge across different cultures. The AAA ICDR Foundation provides much of the financial support to the foundation. The AAA ICDR provides much of the financial support for the foundation, as do many of its arbitrators and mediators, and grants have included funding for Mediators Beyond Borders, the Prison of Peace Inmate Mediation Training, Association for Conflict Resolution Elder Justice Initiative, Conflict De-Escalation Training for Police Officers, the Coalition on Racial and Ethnic Justice, Promoting Peace and Tolerance Through Leadership and ADR Training for Women in Belarus, Russia, Ukraine, Bolivia, Colombia, Ecuador, Panama, Peru, Venezuela, the Ohio State University School of Law Divided Communities Project, and the New York Peace Institute. Since its inception in 2015, over $6.5 million in grants have been funded. Wow. $229,000 was the average grant amount funded during the 2023 annual grant cycle. 94 projects have been funded to date. And once again, to point out again, many of the donations to the foundation are from panelists themselves donating money, which is just a really wonderful thing. So we're very proud of the foundation and all the good work that it does. And you talked about how you can expand kind of the general public's knowledge of ADR through the foundation. That's one of the ways that we do it, by funding these wonderful projects that have contact with just, folks in the general public as opposed to just the legal community.
Yes. Thank you so very much. Oh my goodness, this has been interesting. I don't even want it to end. It's a masterclass. Thank you, Aaron, for coming on the show. And I believe that all you've stated here that potential users would, opt for arbitration via the AAA whenever the need arises. Thank you so very much for coming on the show. All right.
Thank you for having me, Chinwe. It's a pleasure speaking with you. And like I said, I'm happy. I always enjoy talking to folks from abroad, explaining how ADR works in the United States.
All right. Thank you so very much. All right. Cheers. Bye. Take care.
Bye.